afternoon, everyone who's here on the East Coast, and continuing good morning to all of our West Coasters. Um, as a note of housekeeping, unfortunately, Cynthia Wilkinson, who is going to be joining us for this panel, is not feeling well, so she will not be able to join us. So I'm going to give a brief introduction to our amazing two panelists, and we will get this show on the road. Before I introduce our panelists, I just wanted to make a note in terms of our planning for this program that we were really excited to do not only our implicit bias panel on judges and juries, which will be coming up next, but really take some time to examine how systemic racism impacts all of us, the work that you all do, how we all interact with our clients, how we interact with our fellow attorneys, and really take some time. I think a lot of people have been doing this. I think a lot more could do it. Take some time to really reflect on themselves, their own actions, and how they can further the cause of anti-racist lawyering and just being anti-racist in general. So I'm really grateful that we can have this panel. I'm really grateful to Phyllis and Carla for being here for this panel. So both of these amazing panelists are NELA board members. Carla Brown is admitted to practice in state and federal courts throughout Virginia, the District of Columbia, and Maryland. In 2014, NELA recognized her as Lawyer of the Year in recognition of outstanding dedication to civil rights, equality, and justice. In 2015, 2017, and 2018, Carla was ranked a top lawyer in plaintiffs' employment law by Washingtonian. In 2018, Law Dragon selected Carla as a top 500 plaintiff employment lawyer. Carla has an amazing amount of accolades. She's done a huge amount of work, and she's a vital part of NELA. So welcome, Carla. Also, we have Phillis Rambsy joining us out of Tennessee. Phillis is the owner of Rambsy Law PC, which you might gather from her background, or some of her awesome swag, which is fantastic. She serves clients in Tennessee, DC, Maryland, Virginia, and Kentucky, and she is primarily focused on representing workers in matters of wrongful termination, discrimination, harassment, and breach of contract. She also assists workers in negotiation of employment contracts and settlement agreements. Her commitment to working on behalf of workers is part of her overall commitment to eradicate systemic injustice in all realms of society. Her professional mantra is based on the edict to seek justice, defend the oppressed. Phyllis got her BA from Spelman College, her master's in English from University of Kentucky, and her JD from University of Michigan Law School. So thank you both for being here. I know you both have a lot of very personal experience with this topic, and I think this will be a great chance. If anyone has questions or comments, please go ahead and put them in the chat panel down below. Make sure that you do the drop down to all panelists and attendees so everyone can see the questions that are being asked. So Phyllis and Carla, I will give it up to you.
Thank you, Ashley, and thank you for assisting, well, really doing most of the heavy lifting and putting this seminar together. Good afternoon, good morning, good day, wherever you are, whatever time zone you're in. If you are up and at it at this time, even if you are still in the bed, just good, because it's turbulent time. So I have told people almost every day at the beginning of this pandemic, I just said, if you can get up and get out of the bed every day, it's a good day. Now I'm just saying, if you can open one eye every day, it's a good day. So just good. A few things before we start. First, shout out to Cynthia Wilkinson, who put so much into this panel discussion and cannot be with us, as Ashley said. Cynthia woke up sick this morning, so we're thinking about her, and we hope we stay true to her thoughts. We've had a lot of discussions about this panel, so we will still be, using a lot of the information that Cynthia has given us. Another thing that I just want to clarify, if you look at the description of our panel, it has the word training in it. It says this training will provide tools to identify the implicit and explicit biases in our own practices and make us stronger advocates. I just want to give a word of caution that we don't actually look at this panel as a training for a number of things. First of all, we're going to be talking about racism and bias in this panel discussion, and there is no way that we can eliminate racism or bias in 75 minutes. We are not that arrogant to think that. We are good in a lot of areas, but we are not so good and not so arrogant that we think we will eliminate bias or even make people understand that they have bias in 75 minutes. So rather than looking at this as a training, we want to just call this panel a call to recognition. It is a call, an invitation to recognize that bias is, and racism, and we will use the word racism a lot in this panel, but it is widespread in our industry. So many of us understand it as workers who is important, attorneys who represent workers, that there is racism and bias that our clients experience. And that is true, and many of us fight against that. But the practice of law is inherently biased and racist in itself. The courts can be racist and biased. Our colleagues can be racist and biased, and even the way we deal with our clients can be racist and biased. And so we just want to acknowledge that up front and let you know that we aren't trying to step away from here and tell you to change your whole practice or change your whole life, personal or professional, but this is just a call to recognize that racism does exist, even among those of us who do good work. You know, doing good work is not a proxy for being a good person. And it does not mean that you're not a good person if you happen to have some biases, if you happen to exhibit some racist actions. So we want to put that out in front. And all we're asking you to do in this panel is, first of all, recognize the ways that you may have perpetuated racism and bias. And number two, recognize the ways that you can take concrete steps to eliminate racism and bias. So just wanted to make that clear. Also, a little housekeeping. The chat is available for questions. We are also not so arrogant to think that we are saviors, that we know everything about this topic. And so you do not have to wait to the end to ask questions. In fact, as we are discussing, as we are talking, and that is what this will be, we are not saviors. We don't need any more saviors. In fact, we need more solutions. So as we are working toward solutions, as we are working toward recognitions, please put your questions in the panel, in the chat panel, and we will definitely get to them as we go along rather than waiting to the end. One of the big problems with racism is that it silences so many people. It is that because of the systemic structure of racism, there have been people designated experts or people designated saviors who supposedly know more than others. And we don't want that panel to come across as that. We are sharing some of our personal experiences, some of our professional experiences, and some of our research experiences. Having said that, we know that nothing is monolithic. So if you have things to say, questions to ask, comments to make, or even objections to make, please put them in the chat. And as we go along, I will try to multitask and look at the chat. Ashley's going to help me out and we will address those. And also shout out to the previous panel and my colleague and board member, Marcus Keegan, who apologized for his outfit because he's on vacation. I make no apologies about my outfit this morning. For the last few months and probably for the future going forward, I will wear a Black Lives Matter t-shirt. I will wear Black Lives Matter mask. I will have Black Lives Matter stickers on my car, and I will not apologize for it. When we finally get back into real court, which is court that's not online, I will probably wear it under my suit coat. So shout out to Marcus for apologizing, and then shout out to my panelist, Carla, who is also representing in her t-shirt this morning. If we do nothing else, even if you need to leave this panel and go do it, go vote. Make sure you vote. It's critical. We won't get into all of that, but we know how important it is. So go vote sometime before Tuesday evening. All right, so we are going to get started. Again, this is not a training, not a lecture, not a time to embarrass anyone. Instead, it is just an invitation to realize the very real ways that racism plays out in our industry. And you know, there's been a lot of talk about implicit bias. And in fact, most CLEs today or most seminars, there are so many seminars on implicit bias, and many people have recognized implicit bias. Implicit bias is in some jury instructions. And implicit bias does exist, but it must be understood that implicit bias is the child of racism. In other words, implicit bias is allowed to exist because racism exists. And so while a lot of people are comfortable talking about implicit bias or willing to talk about it or even willing to admit that they possess some implicit bias, people really get scared when you start talking about the word racism. I think some people think if you say, oh, you exhibited a racist act, particularly lawyers who do good work, You know, a lot of lawyers will say, but I represent workers, I can't be racist, or I'm a civil rights lawyer, I can't be racist. And so while people have recognized that term implicit bias and been willing to study it and talking about it, so many people back off from that term racism. But indeed, racism allows implicit bias to exist. And so we will not back away from the term racism in this seminar, in this panel discussion. In fact, it's so important to understand racism in order to understand implicit bias, in order to understand some of the obstacles that we face dealing with our clients, dealing with the courts, and dealing with our colleagues. And so when we use the term racism throughout this panel, we are not accusing anybody of stepping on a man's neck for 8 minutes and 46 seconds. We are not accusing anybody of using the N-word in a laughing matter or in a joking matter, but we are simply saying that racism is pervasive in this society and it does not escape the practice of law. Even more, racism does not escape the practice of law for those of us who do good works, because we can still do good works and still be biased. One of the things that I told my panel members is that I look at racism the way that I look at cancer. I am from a family where cancer runs rampant. So many people in my family haven't been impacted by cancer, including my own mom. And because I know that the cancer risk is high in my family, the science just says that there in my body somewhere is a cancer cell. It may never develop, it may never come out, but hidden in my body somewhere is a cancer cell. But because I know this, because my grandmother died of cancer, because I've had an aunt die of cancer, because my mother is a cancer survivor, I take steps to combat that cancer before it comes out. So I've had genetic testing. I was a woman who had a mammogram way before the age of 40. I'm having a colonoscopy in the next few weeks. All of that I do is because I know the cancer is somewhere there, and I'm doing those things to hopefully, if not ward off cancer, to catch it early. And I think we can think about racism in that way. Most people have some racist thoughts, racist actions, even if they have not manifest externally, they are internal. And as long as you realize this, you can do those things to ward it off. So you can go to seminars on this. You can talk to your clients about it. You can talk to your colleagues about it. You can inform or make changes in the court about it. But you have to know it's there. And the same way that there is no nice word for cancer, I always tell the story that when my mother was first diagnosed with cancer and we looked at the pathology report, and I was in the halls of the oncologist office reading the pathology report, and there was this long word that I did not know. And I turned to the oncologist and said, "Hey, is this a nice way of saying she has cancer?" And the oncologist said, "There is no nice way to say cancer, because if I say it too nice, you won't take it seriously." And I think we have to think about racism in those terms. We can't just say, "Oh, somebody did something bad today," or "I refuse to take this client because they just were not articulate," or "Oh, wow, Phyllis, your family should be so proud of you that you're an attorney," as if to say that nobody else in my family, because I happen to be a Black woman, is doing anything. We have to call it what it is. And we have to understand, as I said before, the implicit bias is the birth child of racism. You know, if we use a health analogy of today, we can think about COVID-19. Most of us since March have just assumed that COVID-19 is everywhere. When I go to the grocery store, I assume somebody has it. When I get a package delivered, I assume the delivery person who delivered my package has it. Whenever I have to go out in public, I assume that COVID-19 is somewhere in the air. When I am jogging, I assume that COVID-19, that the person that just jogged past me had it and blew it into the air. And because of that, we've taken necessary precautions. We wear masks. We wipe down everything. We use way too much Lysol, at least in my household. And we must think about racism in the same manner, that it is everywhere. It may not always come out. It may not always manifest in kneeling on a man's neck for 8 minutes and 46 seconds. It may not come out as saying the N-word, but it is essentially everywhere. And we cannot sugarcoat it. We cannot try to make it nice to make people comfortable, because while it may make people comfortable by not saying, calling it racism, it also doesn't solve the problem. And so what we just want to do today, again, is talk about the ways that it exists even in our industry. Again, we do good work. Shout out to everybody watching this panel. Shout out to everyone in NELA. Shout out to all the people who have dedicated their legal careers to helping people, particularly helping workers. But just because we do that does not mean that we do not have a work to do on ourselves. Just because we may win a big verdict in a race discrimination case does not mean that we have some very real biases that we have to confront ourselves. And so again, this panel is just a recognition of that and a way to think about two major things. What have we done to perpetuate racism, and what can we do to eradicate racism? And so I'm going to turn it over to my very capable colleague, Carla. She is going to start some things. And we have a PowerPoint, don't worry about, we will be skipping around in the PowerPoint a lot. But as we do, it also should be in the material. So if you miss anything, definitely let us know and we can definitely go back to it, or you can look at it in the materials.
All right, Phyllis, can we look at slide 14? And this is certainly one word that you've heard if you've talked about implicit bias is microaggressions. I want to talk a minute about what microaggressions are and then get into some more specific examples. We all know microassaults, right? That's overt, microaggressions, insults, etc. We've got micro insults, which are a little bit less than the microaggressions. And then we've got our last category. Oh, micro insults. We should have micro insults next, and then micro invalidations. So micro invalidations are comments and behaviors that deny the experiences of marginalized group members. I want to talk a little bit about 2 and 3 and things that I see on a frequent basis. If we could go to slide 15. This is one of my favorite articles. I quote it in complaints that I file. I quote it in briefs that I filed to the court, but it's The Racial Politics of Speaking Well. It's a 2007 article. And basically the writer examines hurtful and insulting words like articulate that describe Black brilliance, when those same words would never be used to describe the intelligence or prose of people that are Caucasian. So the word, one of the quotes in the book, which is the second one down, is the word perfectly conveys, to quote, believe it or not, George Bush, the soft bigotry of low expectations. It literally comes down to that. When we say it, what they're really saying is that someone is articulate for a Black person. If you like sports, I don't, I'll be honest with you, I don't spend a lot of time watching ESPN. I don't spend a lot of time watching sports, but you can almost play a drinking game to this. Every Saturday, somebody's going to go, wow, what a bright young man, or what a articulate young woman. Why wouldn't you expect that from somebody who's at Stanford on the golf team? This is what happens, or on the basketball team or somewhere else. So this is one thing that I hear all the time. And I'll tell you, I've personally heard it myself. People have said, wow, you're really articulate. Or to my husband, why wouldn't you think we both were? We're both lawyers that went to law school. Why wouldn't we be able to put 2 sentences together like anybody else? So I find this a lot. This is probably my favorite quote from D.L. Hughley, who's a brilliant comedian. He said, people want to be up in arms when someone uses the N-word, but it's the subtle words like this that are more insidious. It's like weight loss. The last few pounds are the hardest to get rid of. The last vestiges of racism are the hardest to get rid of. Now, I certainly think we talk about 2020 all the time. It's terrible. Corona, the killing of Black folks, everything has been terrible in 2020. But I'll tell you what I don't think is terrible in 2020, that we're finally having conversations about things that have been in the community that have been insidious for years, that we are finally getting on the table and maybe actually attacking. So I'm not going to say that 2020, at least on this, is the worst thing that has ever happened. It's about time. It's overdue. It's 100 years overdue. It's 200 years overdue and centuries overdue. And we even have the largest corporations in the world talking about Black Lives Matter. If we look at slide 16, here we have the biggest corporations in the world say Black Lives Matter, but their records raise skepticism. I think it's great that people had that took the time to pen Black Lives Matter statements. I'll just tell you personally, as part of a group that I'm involved with, affiliate of NELA, we did reach out to our Supreme Court in Virginia and we asked them for Black Lives Matter. It was far overdue. It was at the end of the summer. What we got back is a one-page quote of, I guess, different people over the centuries, not exactly what we were looking for. But I think we have to be asking different entities, different organizations for more than statements, but I guess a statement's a start. I love this article, one, because what it basically says is that employees were pushing people because companies were afraid of losing customers, afraid of their roles and inequities in hiring and pay promotion, toxic workplace. But what the Washington Post really noted is, yeah, they're all saying it, but nobody's actually doing it. And I think that's one thing that we can look at for each of us. I'm sure lots of firms that are on the call had Black Lives Matter statements, but beyond that, what else has been done? What's been done in the intervening months? And I think we can't forget that the way we spend our money and who we support is directly indicative of making a serious change. And so while Black Lives Matter matters, obviously march, protest, strike, vote, but Bank of America, for example, paid a $4.2 million settlement. This is covered in the Washington Post article last year for discriminating against Black, Hispanic, and female job applicants, but only 5 of their senior leadership are Black. Goldman Sachs paid $9 million and in 2019 to settle federal allegations of race and gender bias. I think I'm hearing a little bit of an echo. Of the companies in Standard & Poor's 500 stock index, 187 of them did not have a Black board member, according to Black Enterprise. And African Americans comprise a fraction of the senior leadership, 3.1% at Facebook, 3.6% at Google, 4.4% at Slack, 5.3% at Twitter, 2.7% of executives at Microsoft. I think these are businesses that we all use on a frequent basis. We use them in the law and we use them with our clients. And that's the statistics that they're posting based on their own records. Amazon didn't disclose demographics of senior leadership, but the report shows that probably 8.3% of US managers are Black. And so we have to ask ourselves, how are our own companies doing? How are our own companies addressing diversity and race? And I think it's the same situations in our own offices. So I certainly think that Black Lives Matter should be at the forefront of this. I mean, I think it has a relevant place in court. If Cynthia were here, she asked a question I won't ask as brilliantly as she did, but her question was, there was, I guess, some discussion about how aggressively lawyers should be about putting Black Lives Matter in front of the court. How receptive will the courts be to these movements? Quite frankly, I think it's on the tip of the tongue. I mean, even in DC, there was discussion about inappropriate things that the court had said itself. I mean, these are issues that are percolating right now for people who haven't had to pay attention to them for years or have had the luxury of not looking at them for years. So I think it's something that we want really to continue to push. And I don't see how any case could be argued without looking at the Black Lives Matter movement that's happening now, or the focus on these microaggressions, these last vestiges of racism that we've been trying to break down in the last few months. Slide 17 is a case that came out of the Fourth Circuit this year. If we go back one, the case is Wayne Jones versus the city of Martinsburg. And I'll tell you the site is 726 F Appendix 173. It's came out in June. I think the opinion was released in July, so after George Floyd, but decided in January. And the facts of the case, and one of the reasons I think this case is an interesting one, is it does give us good language for pleading and also for addressing and briefing issues relating to Black lives in the workplace, Black lives in general. But the facts of the case are basically that it's almost midnight on March 13, 2013. The officer spots this person, Mr. Jones, walking down the street in Martinsville, Virginia. He wasn't on the sidewalk. Apparently, that's why they said they pulled him over, because there's a city ordinance that says you have to walk on the sidewalk. He's a 50-year-old Black man who's been diagnosed with schizophrenia. And after a minute, he asked him, do you have any weapons? Mr. Jones doesn't exactly know what he means by weapons. They ask him guns, knives, etc. He says, yes, I have something on me. They tell him to get against the car. They tell him to get up against the car. He refuses. He says, what do you want? Basically, a second officer rolls on the scene, ends up tasering him. Before long, you have 3 more cops and they strike him in the neck, they kick him, they put him into a chokehold. What's said in the case is that on the dash cam video, you can hear him gurgling. And then someone says, oh, he has a knife, at which point they load a total of 22 rounds in 2 seconds into him. He's not moving, he hasn't fought, but he can't put the gun down. He can't put the knife down when they tell him to put the knife down. So the question before the Fourth Circuit really was whether the officers were entitled to qualified immunity. Ultimately, the Fourth Circuit said no, but the language of the case is very good. The last paragraph of the opinion says, although we recognize that police officers are often asked to make split-second decisions, if we go to the next slide, we expect them to do so with respect and with respect and for dignity and worth of Black lives. So if let's go back 2 slides, maybe one more. There we go. And this is the phrase that stood out: respect and dignity and worth of Black lives, right? That's what we ultimately have in the workplace, et cetera. It means that our careers as Black people mean just as much to us. The promises that employers make to us mean just as much. And so this is a case that I think hopefully will get some traction. While it's a criminal case, I think it has cross implications, very good language here, and a discussion of George Floyd out of this paragraph. But this was a good case I wanted to point out that's come out recently. And then I want to go back in time a little bit to a case that is slide 19. And this case is the United States versus Curry, another criminal case, but again, with very good language. And this is slide 19. This is an appeal that presents a question of whether the Fourth Amendment's exigent circumstances doctrine justified the suspicion, a suspicionless seizure of the defendant, who is Billy Curry. I'm not a criminal attorney, and I know those of you, I listened to Eric's talk beforehand, so I'm gonna get all the premises wrong, but I'm just gonna focus on the facts and the language that I think is helpful for us while we address some of these issues. Basically, the police seized Curry after responding to a number of gunshots that were fired in an area. There's a couple of men that are standing by calmly and separately walking in a public area. They ultimately search him. He has a gun. They arrest him. And the question before the court is whether his motion to suppress evidence, which is the gun, should be upheld. The court does confirm it, but this case was getting a lot of attention where I am in the Fourth Circuit, in part because it was an African-American judge who was focusing on the statements made by a Caucasian judge. Great language again. If we look at slide 20, while it's a long one, it basically says, that there's a recognition in the first paragraph that when I read the first line of Judge Wilkinson's dissent, I was heartened by the thought, well, at least he acknowledges there are 2 Americas. But this glint of entitlement was to serve as a soapbox for his charge against the majority's decision, which wasn't to suppress the evidence. And his last line is he basically says, through his opinion, my colleague contributes to the volumes of work gifted by others who felt obligated to bear their burden to save minority or disadvantaged communities from themselves. So certainly Judge Gregory is the author of this concurring opinion. He is an African-American judge who's really talking about the fact that as a Black person, you live in one America. Sometimes there can be 2 separate Americas and what that means. And then in slide 21, he gets into issues that we address today, right? But we know that many of our fellow citizens already feel insecure regardless of their location. In a society where some are considered dangerous, even when they're in their living rooms, eating ice cream, asleep in their beds, playing in the park, standing in the pulpit of their church, bird watching, or exercising in public, it's within their own communities that you sometimes feel the most secure. So I think this case is a helpful one on explaining a couple of different things about what America looks like, what it can look like in the workplace for 2 separate people. And then just the last thing I want to share on this case in the next slide is a series of references that he makes. And he talks about, if looking in the third line and quoting an opinion, a dissenting opinion from Justice Sotomayor, where describing the talk that Black and brown parents frequently give to their children out of fear about how an officer with a gun will react to them. And also that in certain communities that people coach their kids to be compliant and to do whatever officers say, honestly, in the hopes that they return at night. So if you're looking for some help on understanding why your Black clients feel the way that they do or how they approach things, it's in case law. It's available. I mean, frankly, you can listen to your clients. I think that's the biggest thing that we can all do. And the prior panel made an excellent point, talking to your client. Rebecca, I think Salata made the point, talking to your client, finding out what they want. But if you need help describing it to the court who might not be able to address it, these two cases in broad, and I've just pulled out pieces of them, I think are very helpful to describe what is going on right now. They're very helpful to the court, and of course, nothing new on that same token. And Phyllis, I don't want to skip over any opinions that you may have on this either.
No, great job, Carla. Great, great job. I will turn my camera back on. No, great job. I think, can you hear me? I think you can hear me. I don't know why I'm can't be seen right now.
And I think I'll just say one other thing that I found helpful over the years and may or may not be helpful to you, but in slide 20, I believe it's 23, we just included the EEOC's prior study. This is the study on workplace harassment that was done in 2016. I know some of you that are NELA members participated in that as witnesses or attorneys that were interviewed. And I would just remind you that when it talks about the business case, the section on the business case for ending harassment, I think crosses over to discrimination. And one of the things that the EEOC noted in that study really was just if you can't get employers to understand it from a human aspect and you can't get them to understand it from a legal aspect, I thought they did a great job of breaking down the business aspect of it, the time and energy. And frankly, I cite this in my demand letters with frequency if you're looking for something else to cite. Time and energy and resources that are diverted from the operation of the business to legal representation, settlements, and litigation, also decreased workplace performance and productivity, and increased employee turnover and reputational harm. So when we're attacking this in court, I think this is there's cases that are giving us fodder for our complaints, for our briefs, for our demands, and also just addressing these items in general. One other thing, I would just like to make the point on the practice of law. Slide 32, and I don't know if the slides are coming up anymore, but I'll tell you, it's a California bar study that found that Black and brown lawyers were punished, placed on probation, suspended, disbarred more frequently than other lawyers. I found this to be the case in Virginia. The only lawyers I know that actually were disbarred are African-American lawyers, despite the fact that I've seen a lot of conduct from all lawyers that didn't result in that. And that includes dismissals, DQs, et cetera. So I certainly think one of the things that I have done this year is I've run for our bar council. I didn't get put on. I wasn't popular enough in my jurisdiction. But you know, I think it's something that we should all be thinking about because we're never going to make any impact in discipline until we are actually on some of these bar committees as well. And, you know, as members of NELA, I think it's an important thing to do. And, you know, I found that the bar organization near me, at least, is a deeply entrenched one. People covet their titles. They hold on to them for 20 years. I'm going to run again next year, and I'm going to run the year after that, and I'm going to run every other year until they actually put me on one of the panels, because the figures that we are seeing are striking and shocking. And I think it's an indication from the courts. I think it's an indication that the courts have their Black Lives Matter statements too. But then ultimately, when they're asked to make decisions about lawyers and subjective decisions, the data shows that they're making it unfairly. You know, and I hope we all do as members of NELA. And I'm lucky enough to be on the Ethics and Sanctions Committee for NELA. One of the things that I always look at is when I read these opinions where the court has sanctioned a lawyer or their client, I have a lot of questions about how the court makes those decisions as well. I never believe the facts as they're written, and frankly, they don't align with the lawyers who tell us that. But I think what we're seeing is that the courts are going to continue to say one thing, maybe do the other, unless we are really in there holding people accountable and helping the courts make some of those decisions. So that's another. I'm not sure, Phyllis, do I still have you here?
Yes, I'm still here. You just can't see me. They're trying to get my video back. But you can hear me.
Yeah, so, I mean, I guess that's just one other thing. And then looking at the last slide that we have, which is the "you don't look like a lawyer" slide. I mean, quite frankly, I think Phyllis addressed that at the beginning. You know, there's no certain way to look, and there's no certain way for people to be made up. But I think it's something that, you know, we should think about. I certainly have had comments made to me that I am trying to figure out how to frame appropriately. And I guess one last point I would make before I hush for a minute is, as an African-American lawyer, I think a lot of the discussion that's going on is discussion that needs to be had. I think it's intellectual for some people. I think they're awfully committed, but I've also had people ask, you know, come up to me and attempt to have conversations with me. I get to have my own conversations in my own time, and I think people have to respect that. I've been asked a lot of questions about the Black Lives Matter movement. Every organization that I'm in that put out a statement, I was involved in it. I'm tired, I'm exhausted, and I don't necessarily want to talk to everybody about every issue. So I appreciate people who care about the movement. I would just say, as Phil said from the beginning, we are all different. We are not pretending that we have all the answers. And I'm just telling you from my perspective, I pick and choose who I talk to about whatever issues I decide to talk to on this frame. Doesn't mean that we're not here to answer questions that you may have, but I don't speak for everybody. I never pretend to speak for everybody.
Thank you. And they got my screen back. Thank you, Pedro. Thanks, Carla, for that. You know, there are going to be many panels during this seminar, during this fall seminar, based on how can we get the courts to change? How can we get the courts to approach that? And Carla just did a really wonderful job on that. But as I said in the beginning, there are two more C's. We have to get the courts to change, but we also have to get our colleagues to change. And we have to understand that we need to be good colleagues. And one part of being a good colleague is to recognize our own bias. The practice of law has a race problem. NELA has a race problem. Even attorneys doing good work have a race problem, and we cannot avoid that. One of the things about racism is that it's not only a systemic structure, but it's also a historical structure. The entire practice of law is built on racism, meaning that the practice of law, you know, the laws, even the way the laws that came about, most of the laws came about, they were racist laws, you know, slavery, just to name a few. It's a racist law, and we still feel the impacts of many of those laws. And so in recognizing how we have perpetuated racism and bias, and also how we can address it, we have to look at how we can interact with our colleagues. And that's not just colleagues that do the good work with us. And I will continue to repeat that I'm pretty sure that everybody attending this panel is doing the good work. Everybody in NELA is doing the good work. But we still have to look at ways that we have to recognize that doing the good work is not a proxy. And so in looking at how we have perpetuated racism and bias, and also how we can address it, we have to look at that in the context of how do we interact within the practice. So that's not talking about how do we make good arguments in court, how do we write these fantastic briefs, how do we make these amazing arguments in court, but how do we interact with our colleagues? The first thing we can do is look around our firms. And I get it more than anybody as a firm owner. It is expensive to run a law firm. It is expensive to pay people. It is expensive to pay payroll taxes. But let's look around our firms. How do our firms look? How do our maybe Ashley or someone can jump in on the chat, and at NELA as an organization, and I do refer to NELA as a social justice organization. But even looking at NELA as an organization, how many attorneys of color do we have? You know, how many Black attorneys do we have? What outreach are we doing? As a colleague, are you doing those things to perpetuate racism? Are you winning big verdicts in racial discrimination cases, but then making offhand jokes at social happy hours? You know, are you doing those things and writing great briefs and attending seminars, but then doing things in your personal lives? Are you saying Black Lives Matter on one hand, but then complaining that the Black Lives Matters protests are coming through your neighborhood, or complaining that you feel unsafe? So those are some things that we have to look at when we're talking about being good colleagues and doing the good work. And I may be frozen. I don't know. I'm getting my message again that my internet is frozen, but if it is, hopefully you can still hear me. So when we talk about being good colleagues, we also have to look at the hard questions and realize that doing good work does not mean that we are saviors. I made the comment somewhat jokingly to somebody this week, but it was very true. And that is, I personally happen to, identify with the Christian faith, which means ostensibly I have a savior, so I don't need another savior. Many of your clients will come to you. Many of your colleagues will already have their own faith, so they don't need, a savior. It really is essentially in itself even racist and biased to think that you can be so arrogant that you can be a savior, that you can save a race, that you can do it in 75 minutes, that you are the expert on all things race. Taking a race discrimination case does not mean that you understand inherently the Black community. Wearing a Black Lives Matter t-shirt does not mean that you inherently understand the Black community. And so in talking about how we can, again, recognize how we have perpetuated racism and what we can do to eliminate racism, we have to start with ourselves and realize those mistakes that we've made. And they may not even be mistakes that you realize you've made. That's when we talk about implicit bias, things that are just in your head or things that you may do without thinking. But I'm not going to say problems. One of the issues with implicit bias, even that term, is that it really allows a lot of us to escape responsibility. Because we use the word implicit, we are allowed to say, oh, I didn't know I was doing that. Oh, I didn't realize my comment would hurt someone. Oh, I'm sorry you were offended, or I'm sorry that you feel that way. But we have to understand that just because we didn't mean to do it, just because it was implicit, because it was ingrained in us, does not mean the hurt is any less severe. And as we go from talking about what we can do in our court cases, we also have to understand that we have a responsibility to change this practice area. We have a responsibility to make sure our firms look different. We have a responsibility to make sure that we give voice to different people. There is nothing more disheartening than going to a CLE, than going to a seminar on implicit bias, on racism in the profession, and not having one person on the panel who is from a marginalized or oppressed group. There is something really wrong with that. There is a book now, it's on our reading list, it's called White Fragility. It is getting so much attention. It's shot to the top of the bestseller list after George Floyd's death. It's by a white woman, and it's actually a good book. But there is also something disheartening about the fact that the #1 book on race after the death of George Floyd would be by a white woman. And there's nothing wrong with white women, by the way, so don't anybody get me wrong, but people have been doing this work, but because of the structures that we have in place, they haven't gotten attention. Even within our industry, people have been doing this work. Kimberly Crenshaw has been doing this work. People like Patricia Williams, they've been doing this work. Some criminal attorneys, I'm glad that we focus on some criminal cases because the criminal attorneys have been doing this work. And that is, I see a question in the comments and I will get to that, but we have to understand that nobody has a monopoly on doing this work. Doing this work, good work, is not a proxy. And also you have to listen to the voices of those from those marginalized groups, from those oppressed groups. The work that we do, we obviously have to have some very hard choices. And that is, we have to make the choices of what cases can we take? What cases can we afford to take? What are the damages in the cases that we take? But one thing that we can do as colleagues, as we're talking about cases, because we all talk about cases with each other, you know, we have a very robust listserv in NELA where we get advice from each other all day, every day. But one of the things that we must do is recognize our bias even in talking about cases. Why did you not take a particular client? I shared with Cynthia and Carla the other day that I had to check my own bias in a case because I was discussing a case with my office and I kept saying, oh, it's a good case, but she only made, or her salary was only. And I realized that I was saying that to the client. Well, while it wasn't that big of a salary, which is actually a shame and is more about more an indictment on our system that doesn't pay people enough to live, I realized that when I kept saying you only make, you only do this, I wasn't paying attention to my own bias. And so we have to recognize that to be a good colleague, we have to understand the things that our colleagues go through. We have to understand that sometimes we have to step back, even when we may have a platform or an audience. Maybe we should give that platform or audience to someone else. And we also have to understand that some of our colleagues are struggling. It is already hard to practice law. It is very hard to practice this form of law. And to be a Black attorney and practice this form of law means that even pre-pandemic, you had to get up in the morning, drive to your office and hope you wouldn't get pulled over by the police, go in your office and hope that they recognize that you belong in the office and not that you're just someone coming off the street. And these aren't things that we're just saying as hypotheticals. I'm actually describing an incident that actually happened to me within the last few weeks where I went into my office building after not being in there during the pandemic, and the security guard threatened to call the cops on me until he realized whose name was on the directory in the lobby. But these are very real things that your colleagues experience. And so in order to be a good colleague, we have to change the way the industry looks. We have to change our firms. We have to change what we give to, you know, if you can say that you're really committed to justice and you really are for workers' rights, but you don't support Black Lives Matter, there's a huge dichotomy in your thinking. As I said, we are not the saviors. We don't want to take up all the time. And so we want to get to some questions. So there is a question: is white fragility when a white person feels offended by a black person comment about implicit bias? Carla, you want to take it or you want to?
Nope, I don't want to.
So white fragility, is it explained as it is explained in the book? It is somewhat that, but it's more this notion that white people are not ready to hear about bias. They are not ready to hear about racism, that they get offended and that they put up a wall or a block to hearing about it. And so then nothing gets done about it. So it's this idea that white people are almost too fragile. I alluded to it earlier when I said some people will be willing to talk about implicit bias, but they do not want you to say the word racism because they automatically think if you say, hey, you said something racist, that you're accusing them of kneeling on a man for 8 minutes and 46 seconds, or that you're accusing them of having a KKK hood in their closet. So white fragility is this idea that white people are not ready to be anti-racist because it offends them to even think that certain words or certain theories could apply to them. And it's a good book. Again, if you look at the materials, we quote somebody who criticizes the book. And I do think that's important to look at the criticisms of the book because, like most things, the book does have some issues, you know. The book does have some issues. It does have a little bit of the savior complex going on in that, hey, I'm not only telling white people how to deal with racism, but I'm saving Black people from racism. And that is inherently a problem. And I think our industry is particularly susceptible to that problem because we are doing the good work. We are the ones who know the legal precedent. We are the ones who know what works in court and what doesn't work. And we are the ones who studied the circuits and studied the decisions. However, none of that is a proxy for truly understanding racism and for truly combating our own racism. You know, we've all heard the joke that somebody will say, oh, you did something racist, and someone will say, I'm not racist, I have a Black friend. And that's how attorneys who do this work sound when they say, I could not be racist, I'm a member of NELA. I could not be racist. I took a race discrimination case. So some of the ideal white fragility is just about not being so fragile, to use the title of the book, in accepting the criticisms and accepting the theories and practices surrounding doing this work.
All right, Phyllis. So I didn't read the book, so I couldn't help you. I can't help on that one. But we do have a second question from William that said, years ago, I teamed up with Terry Cha to increase diversity in NELA ranks. A survey of the members, however, revealed that the job offers to minority lawyers were often turned down because in a small plaintiff's practice, minority lawyer was not willing or able to ride the financial roller coaster. Many had significant law school debts and family obligations. How do we address this concern? So let me just say a couple of things. This reminds me of a situation where my father-in-law is at a church here. I grew up in that church. My husband grew up in that church. Every Black person I know in my community grew up in that church. The other Black churches came out of that church. And so at some point they were trying to diversify, to get a couple more younger members, et cetera, because they're down to about 10 right now. And he said, well, we sent a survey to ourselves and we tried to figure out what the new people would want. And I said, well, there's half your problem. If the survey went to the members who aren't diverse, I don't know how they could really know what the minority lawyers would want coming into here. I mean, I think it's a great effort. And, thank you to you, William. Thank you to Terry Cha for her efforts. But I don't know that that's what the minority lawyers actually said. That's what the members said, that's why the members said the minority lawyers weren't joining the ranks. I don't know that to be the case because I have plenty of Black lawyer friends who have the same economic troubles and who have the same obligations that the white friends that I have, or white lawyers that I had, or any other color lawyers that I had as well. I think the bigger issue is it is a structural racism issue within any organization. If you don't see people who look like you, you're less likely to join the organization. You're less likely to feel like you can be successful in the organization. So if you're invited to join a firm where nobody looks like you, there's no mentors that are like you, it's just a situation that happens. It doesn't mean to me that it's based on economics. I wasn't part of this. I wasn't surveyed, of course, at that time. But I think it's a mentorship problem. And if you're looking at implicit bias, unfortunately, the problem has to be solved by having people who look like you, who make an effort, who continue to do that. I mean, congrats to you, William, congrats to Terry Cha, but I think we just have to keep doing it. I mean, I'm guessing when you surveyed the members, neither Phyllis or I were here, and at least there's some progress that's happening. I hope that continues. But there needs to be more, I hear you. But I don't know that I trust a survey of members to define why Black lawyers have declined to work with them. I don't know that I trust that.
And I would also say about the financial roller coaster, obviously, I always tell people, I do not subscribe to the notion that money doesn't matter or money is not important. Money may not be able to buy happiness, but if I'm depressed or if I have a problem, money surely helps me be depressed in style, and it surely helps me address some of my problems. So I never overlook the financial aspect of practicing law. However, I think that everything is a balance. And when you talk about Black lawyers or lawyers of color or lawyers from marginalized groups doing this kind of work or joining firms on our side, the money is a big aspect, but also the safety. How comfortable do we feel? One thing that I brought up to NELA almost every year is that our annual convention, pre-COVID, always happens at a time when the NBA convention happens, the National Bar Association, which is an association of Black attorneys all over the country, all practice areas. And I've always said that if I wasn't speaking on a panel or on the NELA board, I would probably really have a tough time deciding if I was going to join the NELA convention in the summer or go to the NBA convention, or if I could only afford to go to one, because ultimately I feel safer. I feel more comfortable. I feel more at ease. I feel that the topic matters being discussed at the NBA conference are more relevant to the topics that to the issues that I will face. I think organizations like NELA, we do a wonderful job on giving practice tips, and I've learned so many things and have gotten just great advice for some of my cases. But I think sometimes when you talk about Black attorneys not joining organizations like this or not joining firms, what practical tips are they going to get just for practicing law as a Black attorney, as a marginalized attorney, as an attorney from an oppressed group? Where are we having the conventions? what is going on with the conventions. And I think that's one thing we have to look at too. Again, not that the financial piece is not important, but look at the other things that are also important. Does a Black attorney want to join an organization where at the social hours they hear some things that bother them, whether it be jokes or whether it be people saying, oh, you're so articulate, or your family must be so proud of you. So I agree with Carla that if we are taking a survey like that, we need to look at more things, and also ask the people who have decided not to join this practice area. Why have you decided not to join? Again, finances may be at the top of the list, but there may be so many more things as well. I know plenty of Black attorneys who do employment law at small firms, but they are not necessarily members of NELA for whatever reasons. So I also think we need to reach out to those individuals and ask them, why did you decide not to join? And also look at our own practice areas and how we practice. If I'm going to an interview, or if I was going to an interview as a law student or shortly after law school, and I show up at your firm for an interview, and the only Black people I see are mopping the floors or only answering the phones, then before you even tell me what the salary is, I'm probably going to automatically think that you only think that Black people can be in a certain position at your firm.
All right. And then are there other questions too? And maybe we can talk about clients of color.
I see alternative books. There is a book list at the end of our reading materials. I definitely suggest that you look at some of the things on the book list. Rebecca says that she recommends White Fragility. I do too. I recommend that you definitely read the book. There are some very good parts of the book. And I also recommend, as I said, read criticisms about the book, but the book is a great place to start. It's a wonderful, wonderful place to start. So I am by no means, and even by putting the criticism in our materials, I am by no means suggesting that you should not read the book, because it's a great place to start. Other people ask about reading suggestions. Again, there's a book list, but another great place to go for reading suggestions, and thank goodness for technology, is social media. There are some people killing it in 120, 140 characters, however many characters we get to. There are some people killing it, getting to the heart of these matters on Twitter, on Instagram, especially now in these last few months when we haven't been able to go to happy hour and haven't been able to go to seminars. So do a search for hashtag Black Lives Matters. Do a search for Black attorneys on Instagram, on Twitter. Do a search for George Floyd, because a lot of these pop up with that, for Trayvon Martin. And also, don't be so arrogant to think that lawyers have a hold on this industry. There are some great people doing the work who happen not to be attorneys, but who really get that legal analysis. There's a journalist, Tremaine Lee, who, after Trayvon Martin was killed, about a week after Trayvon Martin was killed, Tremaine Lee wrote every day for about 100 days, and every article he wrote had Trayvon Martin's name in it. The reason that most of us know Trayvon Martin's name is you either read an article by Tremaine Lee, or you read an article from a newswire that was picked up by an article that he read. So also branch out and not just use legal things, because again, we're not only talking about writing briefs and making great legal arguments, we're also talking about being good colleagues. But I highly recommend social media. The first thing I do in the morning is scroll through my social media. I have certain hashtags saved, and I have learned more about different movements, different cases that never get publicity in mainstream media than I ever would if I did not use social media.
And can I just say, I see questions in here. I'm worried that because I do civil rights work, but I might be one of those people who believes that I can't be racist because I do civil rights work. I have 2 African-American associates trying to figure out how to support them. That's what I'm talking about in 2020. We were not talking about this in 2019 or 2018. We weren't getting into these issues or questioning any of that. So I agree, Corona's a mess. Everything that caused us to be talking about this is a mess, but this part is not a mess. And I guess on your question, what do you recommend? I think we should get on the what do you recommend for help might be covered when we get to the clients. And then how do you support your Black colleagues? Here's my suggestion to you. I was lucky enough to be in a firm where people came down and reached out to me, just like, the two guys who were out playing golf together. I didn't play golf at the time, but I think if you have a concern about people in your office, go down and talk to them just like you would anybody else and figure out what they like. That a good way to be supported is to have somebody take an interest in your life and recognize that maybe if you are somebody like me, I'm not a sports person. I'm not the cool girl. You're not going to hockey with me. You're not going to basketball with me. I don't do any of those things, but I am going to work hard for you, right? So if you came down and talked to me about my cases or how I wanted to present something, that would make a big difference. I think, we have to actively debias every single one of us. Me too. I have to actively debias. I have to figure out where my biases lie. And I think questioning some of this, going down and talking to people and trying to figure out how to support them is a step in the right section, I would say. And again, I just can't say it enough. Don't assume that all Black people are the same, right? Like I don't know one way or the other, but not every Black lawyer who's not in our group is doing it because of economic reasons. That's just not the reason. There are more reasons than that. It's more complex for us. So the best way to find that out is to sit down and talk. And I would say, I'll just say same thing for your clients that are Black. Talk to them, develop a relationship. Don't call them once a month. Don't call them every 6 months when the discovery is due. Pick up the phone and figure out what they're going through. That's a big help because you'll find out what people deal with on a day-to-day basis makes a big difference in how comfortable they are with you, how much they talk to you, what they're willing to say to you is sometimes your ability to listen, to try to figure things out, right? A couple of years ago, I had a colleague who had a race discrimination claim where what they essentially did is they called the guy every name in the book, the N-word, every word that follows it at his job site because he refused to do some work for them. And the colleague who was not African-American came back to me and said, well, the liability is there, but there's no damages. He just wasn't that upset. I said, you got to be kidding me. You better go back, sit down and talk to him, bring him in, talk to him, bring him in the next week and talk to him. He's not telling you why he's upset, but there's no chance that somebody went through all that and isn't upset. So sometimes it's building a relationship. And I said, maybe he's not comfortable talking to you, but you need to go in there and ask him specifically. And if you can't ask him, have conversations with them, but you got to spend time with people because this is true with every client. Not every client's going to tell you everything, right? And some people, some people from certain areas are never going to break it down for you, but find out from their spouse, find out from their siblings, find out from something else. Just try. You got to work and you have to try, I think, on these and realize that, there's certain people who aren't going to always feel comfortable talking to you. I'm not the liked person. I'm not a likable person. I recognize that. I'm a little bit of an intense person, probably a little bit annoying, but you got to talk to people and try to get through that. So I think for doing this kind of work and for supporting your plaintiffs, it made a big difference to me, the people who took time to come in and sit down in my office, I guess on Zoom now, but whatever it is.
And talking about the support, not only for your associates, for the person who said you have 2 women of color associates, but also for our colleagues, also recognize that sometimes it's just enough to say, I don't know what to say. One of the most moving messages I got through text message right after the week of George Floyd's death, when, we're already in this pandemic and then this happens and we're seeing these images over and over. Opposing counsel on a case, a defense counsel, texted me and said, Phillis, I have no words. I do not know what to say. I am not trying to play like I know what to say. If you want to try to get together on the sidewalk or outside somewhere because of the pandemic and have a drink, we can do it. But I don't know what to say. And to me, that was so important because all that we got had been getting messages from people who knew exactly how I felt, or so they thought, who were saying, oh, I know how you feel. Oh, you have brothers. Didn't this make you upset? Didn't this make you feel this way? Some of those feelings I may have felt, but you really don't know sometimes how somebody feels, particularly your colleagues and associates or your staff members who are doing this work, but still living their lives as well. So who are still doing this work, but have to go home sometimes to neighborhoods that are not friendly or have to go into office buildings. So admit when you don't know what to say. And also, I cannot say this enough, get away from that savior complex. Get away from that you are the expert. And the last thing that I would say on this is don't always assume somebody's silence means that they don't have a problem. Carla, you brought up a very good point when they said, well, there are no damages. He wasn't that upset. There have been some allusions to the discussion that's going on a NELA listserv, but one thing that has been said was, Oh, well, some of the things couldn't have been that bad because only a few people complained or only one Black attorney complained. Our materials end with, remember I said, let's get outside of the law sometimes. Our materials end with the Paul Laurence Dunbar poem, We Wear the Mask. And sometimes it is not that people are not upset. It is not that we are not disappointed. It is not that we are not sad. Sometimes we have to wear the mask just to get through the day. Especially today, there are many times that I don't jump in a discussion or I don't post something on Instagram. It is not that I mean I accept that thing or that I'm not bothered by it, but you have to understand, particularly people from marginalized and oppressed groups, we have to choose our battles carefully every day. You know, in the last few months, I've had to choose to say, I'm going to wear a Black Lives Matter t-shirt when I run to the store to get Lysol for my family so that hopefully people in my family can avoid this vicious virus. We make choices every day. So because I don't write a dissertation, because I don't give a monologue on Instagram about certain things, doesn't mean those things don't matter to me. And once we understand racism and the power dynamics of racism, we do understand that many people think that they can't say anything. So particularly those of you who may have associates or staff members, they may not be saying anything because they want to keep their jobs. They may not know that you are dedicated to eradicating racism. It is very hard to speak up. And I even speak from a position of privilege in that I own my firm. Nobody's going to fire me for wearing a Black Lives Matter shirt because I am the boss. But that took a progression. I cannot say, I do not know if a Black Lives Matter t-shirt was out when I started practicing law, if I would have worn it to work. Because again, finances do count somewhat, and I did have student loans to pay and bills to pay. So also recognize that silence does not mean acceptance. Silence does not mean that your associates of color don't have a problem. Silence is truly a part of systemic racism and the power structures. We must remember that racism does not exist in a vacuum, and it does not exist on different levels. It exists on a spectrum. And so that spectrum is also very historical. And keep in mind that the history of racism in this country means that it was only a few years ago, really only a few days ago, really only a few minutes ago, that we could be killed for expressing certain things. And so never forget that.
So I had a quick question that I was going to put in the chat, but then I realized I had a video, so why not? As a colleague and friend to people in vulnerable populations, you know, I know there have been times that, you know, we look back on things that we have done or said in the past to people, and knowing, you know, growing along the way, you're like, oh, I wish I hadn't said that, you know, going back to high school when you're like, oh, I wish I hadn't teased that person for that thing. If you recognize that you have, you know, said something that you're like, that was a microaggression, that was a micro insult, I shouldn't have, you know, said that, and it's still within a relative time period, what are your feelings on, you know, if I reach out to you and say, hey, I just said something last week, I've been thinking about it, I think it was not a great thing to say to you. Is that something that we should work on doing, or is it enough to recognize it in ourselves and say, you're going to do better next time? On one hand, you know, I don't want to burden, you know, people in vulnerable populations and people of color just so that I can feel less guilty about something that I said. But at the same time, how do you kind of recognize to the people around you that were impacted, hey, I did something that hurt and I'm sorry?
I definitely think you can acknowledge it, but you do not get to control the person's reaction to your acknowledgement. And so many times I've had people, colleagues, apologize to me for something that they said was racist or, you know, biased, or how they treated me or anything. And definitely appreciate and acknowledge when people apologize or acknowledge it, but you do not get to control the way the person reacts. And I think that's one problem so often, is that somebody will say, well, I'm sorry. Okay, let's go on. You don't get to control if that person talks to you again, if that person wants to work with you again, if that person tells other people what you did or what you said. You don't get to control that. All you can control is your acknowledgement of it. And I do think that's important, to acknowledge it, but you don't get to control anything after that acknowledgement.
100% agree. If you never say sorry, though, I can only think one thing about you. Or if you never tell me that you knew it was wrong, I can only think one thing about you. But I'm real comfortable with the uncomfortable. So it just might be like that for a little while, or maybe forever. It depends on what you said or did.
Yeah. And oftentimes I think many people apologize in order to make themselves feel good. So, they'll say, well, I said I was sorry, but that's only for you. Again, it doesn't take away the hurt. It doesn't take away the damage. And I think the more we recognize that, is like my analogy before, all of us have these biases in us. Like I have cancer cells in me, all of us. Sometimes they pop out. You may need radiation or chemo to get rid of them for the long term, but sometimes they pop out and you cannot acknowledge that. There was never a point when my mother was diagnosed when we just said, she's just a little cancerous. There was, they stage cancers, but there was never a point where we said, she's just a little cancerous. There was never a point where we said, oh, she did such a good job at work today, let's not really think about the cancer. There was never a point when we did that. Years now after her initial diagnosis, there's never a point where we said, she's done so much for the church and so much for her kids, let's not even worry about that cancer part. That's a part of her identity. And that's a part, bias is a part of so many of our identity. And again, it exists on a spectrum. So many people think in levels and say, well, I may have said something inappropriate at the NELA convention, but at least I did not say the N-word. It doesn't exist like this. It exists like this. At one end of the spectrum is a cop that kneeled on a man's neck for 8 minutes and 46 seconds. On the other end of this spectrum is a colleague who does great work, who we probably even like, but who probably said something stupid at a convention, at a happy hour, in a text message that they thought no one would read in a hiring name. Can you say a little bit about Black names that studies show implicit bias against those perceived to be Black in history of slavery? Those who would be horrified about misspelling a white colleague or judge name in front and dismiss it. Definitely, we'll get to that question. Because we're running out of time, we did want to talk about clients as well. We won't get to go in depth to talking about clients, but recognize our bias in even the cases that we accept. I tell the story about, I was a partner at a law firm, and one of our associates did an intake on a woman. It was a pregnancy discrimination case. And after the intake, she decided that we did not, it wasn't a good case to take. I happened, for whatever reasons, to come across the intake. I thought it was a good case on paper, but we all know that mistake. A lot of cases are good on paper and not good. But I ended up calling the woman. It ended up being a fantastic case, to the point that liability was so clear. I think I resolved the case in like 4 weeks. But I later asked the associate why she had initially turned the client down. And the client was a Black woman. She had 3 children. It was her 3rd pregnancy where she had been discriminated against. All 3 children had different fathers. She was not articulate, as we say. She even had, I really had to pull some of the claims out of her. Quite honestly, she had made some personal and life decisions that I probably would never make. However, this woman had a good case. And I talked to the associate about the biases that she had in turning this woman's case away, because I'm sure if she had been a professional white woman at some Fortune 500 firm who had said this, the intake probably would not have even taken that long. It would not have taken 2 attorneys to call back to see if she had a case. So just in talking about clients, recognize our biases from the way we interact with clients, from the way that we can't separate our clients' personal decision or personal lives. Again, many things are cultural. And many things are different. At the beginning of this pandemic, we were slamming people for not socially distancing. There is a group of people who live in houses where they cannot socially distance. And so we have to recognize that in our clients as well. And then with some of the things, you may be representing a client who's been called the N-word at work, and they pull up to your office loud playing some hip hop music. I am a hip hop lover. And I have to even recognize when I'm driving to work, you need to turn your radio down, Phillis, because surely your song is going to skip to a song that says the N-word sometime in your drive. So recognize these things as we deal with clients as well. We won't get to talk about it as long as possible because we have a minute left, but the Black names, boy, what can I say? Paula, I will definitely we can definitely probably talk offline about it, but it's like anything else, not only with our colleagues, but with clients. Names mean a lot. What we call people mean a lot. Many of us take pride in our names, and that's all a part of the systemic structure that is racism, that has said for so many, certain people's names don't matter. Again, racism does not exist in a vacuum. It exists on a historical spectrum. And remember that even the things with names is that for Black people in this country for so long, we did not have names, or rather our names were the last names of our owners or people who contended that they could own people. And so now that supposedly slavery is over, names do mean so much. And I personally think it's a sign of disrespect not to learn how to spell somebody's name, especially because now it's usually in the email. Like, it's always amazing to me when I sign my email with my name and then somebody responds to the email, but they spell my name wrong because I've just spelled it in the email. But I do think that we need to look even at those small things. Again, it may seem like something small because we're not shooting anybody, we're not calling anybody the N-word, but it is just as important. And I think even bringing up something like names brings up a good point, that nothing is too small when we talk about racism or bias.
And just one more point, I think Jonathan Puth made this point on the Metropolitan Washington listserv. If you're somebody who only takes race discrimination cases where there's a specific racial epithet made, or where there's a noose or something like that, a good way to look at your cases is to re-examine that policy. The law doesn't require direct evidence of discrimination. It allows a lot of different things. So I would just say, if you're looking at how to address your clients, I've heard this from more than one lawyer. I've heard it from more than one lawyer in NELA, that unless there's a specific statement there, they're not taking it. Re-examine it in the world that we're in right now. But that's, I think, one key thing that you can do when you're looking at race discrimination cases is it doesn't require you to have a specific statement in order to win. I'll just say from my own personal view too, not every case that I take is a slam dunk. And I'm more proud of some of the cases that actually maybe didn't get as far as they should have than the ones that weren't, because sometimes you got to take a tough case. You know, I just remind you that Loving and Brown versus Board of Education, those cases weren't slam dunks. And as lawyers at NELA, we owe our clients the obligation to take the best cases we can and to push them forward. I know we're out of time, so thank you for having me, Phyllis.
Thank you, Carla. Thank you, Ashley. Again, people, this can't be resolved in 75 minutes. It's ongoing. Please continue the discussion. The best thing you can do, whether you read a book, whether you read a tweet, whether you read a post on Instagram, whether you just later today, shoot somebody an email, pick up the phone, have a Zoom happy hour. I love Zoom happy hours, by the way, if you want to have one with me. It's to just keep the conversation going. Everything is changing daily, but keep the conversation going. Be better in the courts, make the courts better. Be better with your colleagues, make your colleagues better. You be a better colleague, and be better with your clients. Do better for your clients. Racism exists. It's not going anywhere, sadly, for right now, but we can make some strides, but we have got to start talking about it. We can't play around with it. There is no nice way to say cancer. There is no nice way to say racism, but we have to say it. That is the first step above all, and realize that those little racist cells are all in all of us somewhere. It's up to us on how we will deal with them.
Thank you guys both so much. This was
Thank
such
you.
an incredible hour and 15 minutes. It flew by. I didn't know that it was ending quite so soon. Thank you guys. It's just been amazing, and working with you guys is such a privilege and an honor.
Thank you. Shout out to Cynthia.
Yeah, shout out to Cynthia. We hope you feel better. And we hope we'll see all of you guys at our next session, which is Implicit Bias in Judges and Juries, with Rebecca Salata, Tony Haramia, and Judge Bernice Donald from the Sixth Circuit, which will start in about half an hour. So thank you guys.